All right, welcome back to another exciting video. Here we are talking about photo infringement damages and settlements. You got a photo infringement letter and you say, well, what on earth should I be settling these cases for? You know, I'm seeing demands over $50,000, $10,000 demands, $5,000 demands. What will these cases settle for? What should they settle for? Is there a law that talks about how to figure these things out? So let's take a quick look at this blog, and I have a case that I'm just going to show you. It's a case out of the Second Circuit, and I'm going to go down to it here and just kind of talk to you about it. So again, this is general information only. Everything can vary depending on the type of your case. What kind of photo or artwork is at issue? Are you dealing with a high-level photographer that licenses a lot of their work at big dollar values? Are you dealing with a stock photo? Are you dealing with a case where the image was offered up for Creative Commons? It means you are allowed to use it, and then you just forgot to give attribution. And, you know, we're seeing cases like this now. It's like I've given you to the public for Creative Commons, but somebody didn't give me an attribution. So now I'm going to sue you for thousands and thousands of dollars. So we see that as well, okay? So there's a lot of different questions that need to be asked. And what type of site were you using the photo on? You know, is this a case for litigation? Do you have a company that could be forced into court because you're a bigger company, and bigger companies, you know, that tend to have the deeper pockets to take on a litigation, those kinds of things. But here you have it, and here's the case I'm looking at. You can go look at all these. These are some examples from my webpage. I just launched my new webpage, by the way. What do you think? If you like it, give me a thumbs up. Took me many months to get this going, but I'm real proud, real happy and excited to have it. But here's the case I wanted to show you. Bryant versus Media Rights Productions Company, Media Right Production, Inc., out of the Second Circuit. This was a 2010 case, federal court, as you can see. So in this case, the court looked at a similar matter, and the court said when determining the amount of statutory damages to award for copyright infringement, and remember, your statutory damages, this is if somebody has a copyright registered photo, that means they can take you to federal court. If they don't have a copyrighted photo, and for the most part, they're just hee-haw, and they're not going to take you to court. Not to say they couldn't try to file their photo, try to get it registered, and seek quote-unquote actual damages, but really the cases are much more attractive when you can seek statutory damages. Now, that amount is from $750 on the low end for what we call non-willful infringement, on up to, hold your breath, $150,000 on the high end. So the damages in copyright law are really high. They're designed to protect the artist, the creator, the photographer, and to punish and deter people from wanting to use these photos without looking into it. All right, so here's some of the factors that the court was looking at in this. Again, every district's different. These are some facts they may look at. The infringer's state of mind. The infringer's state of mind. So what's that? Maybe you take the photo and you thought it was a fair use. You thought you were commenting or criticizing it. You didn't see any copyright notice, and you're like, oh my God. You get the letter from the law firm, the copyright law firm, and this is, you're being charged with photo infringement. And you look it up and you go, oh my gosh, how'd that photo get there? You take it down quickly. But by acting quickly and swiftly in good faith, that can be a factor that works in your favor to lower the settlement, okay? Now, on the other hand, if you're reckless and you keep it up there for another 4 months and say, you know, want to start a big litigation about it, that can go against you the other way. Now, here's one. The expenses saved and the profits earned by the infringer, that's two things. So say this artist licenses the photo for $500. Sometimes we have news photos. Sometimes we have Hollywood celebrity photos. Maybe somebody licenses a photo for $500. Okay, so the expenses saved by the infringer would be $500 times however long they've been using it and whatever different licensing factors there are. So every company's different. And, you know, an artist is allowed to work by the free market and get what they can. So I'm going to post a link into my into my YouTube channel about Getty Images and how they have a little calculator that you can go through. And some people have used this for a guide when they end up in photo infringement cases trying to figure out, well, how long did you have it on your website? Who was your target audience? How were you using it? Those kinds of different things. Were you using it on a product? Did you use somebody's copyrighted image on your products or shirts or posters? Things like that, wallpaper, all kinds of stuff, okay? So the expenses saved and the profits earned. So again, say you took an image of Muhammad Ali or somebody and you went and it's a copyrighted image and you sold 100,000 t-shirts, well, probably the t-shirts were sold because of the Muhammad Ali image, and probably the copyright holder is going to say, I'm entitled to that money. So that can obviously change the dynamics of what a settlement's going to be. So that's a good factor to look at. Here, tied into that, number 3, the revenue lost by the copyright holder. So the copyright holder, they're going to say, well, in that circumstance, I lost $100,000. We could have sold our t-shirts and our posters, and instead you're over here selling the posters. We lost $100,000. So you can see how, some people think, well, a photo's worth $300. That's all I'm paying for it. I'm going, well, there's a lot of other factors here that go into it. Okay. Number 4, this is important. The deterrent effect on the infringer and third parties. And sometimes when you say third parties, we mean webmasters. A lot of times you hear somebody say, I didn't know it was my webmaster. They used the photo. I said, well, look at your photo. Hopefully you have an indemnification clause. Maybe you can go back after your webmaster to have them pay for it if it was their mistake. But the deterrent need, and this is big because if people don't know about copyright and they're just, everybody's presumed to know the law, and the law is that all images are copyrighted whether or not they're registered or not. I know that's kind of confusing to a lot of people, but the minute you put a creative work of art, fix it in a tangible medium of expression, it is subject to copyright protection. So you're not allowed to use photos unless you have a fair use, unless you have a transformative use, unless you're using something in like a parody. Those kinds of things would be protected. Okay, but there's a factor, a monetary factor to help infringement, teach the lesson, so to speak, okay? Number 5, this ties in kind of with number 1, the infringer's cooperation in providing evidence concerning the value of the infringing materials. So you come in, you take the photo down and work through some type of calculator and say, well, let's work in good faith. I'm trying to get you something for your time and your trouble. I just don't think that amount should be $25,000. So this is what you're working on, but working in cooperation to try to come up with a figure. And again, 6, the conduct and attitude of the parties. Well, I don't know so much about that. Both, parties can get pretty polar opposites in these kinds of cases, but that's a list of different factors. Now, also I have down here the 1202. 1202, this deals with what we call copyright management information. So if in the process of infringing a photo, you were taking off a copyright notice or the photographer's name or something that was used by the photographer, and you can see the different things here. If you're cropping that out, so to speak, there could be additional fees. As it notes here, the minimum award of damages for such a claim under 1202 of the copyright law is $2,500. So that could add to your settlement. And oftentimes in an infringement letter, you will see a quotation, somebody saying that, yes, you are infringing on the copyright management as well. Okay, so it's a separate claim. So the damages can really vary here. That's why I say there's no quick and easy cut way, but we help clients defend in these cases. We have a select photographer that we represent. But if you need some help, whether you're a plaintiff or defendant trying to work through, need some help in a copyright or a mediation, dealing with photo infringement, like I said, we've handled a lot of these cases. These are some general guidelines you should be thinking about. There's our phone number up there, and as you can see, we are here and able to assist you, okay? Give us a ring. You know where to find us. Here we are on the web at attorneysteve.com, also known as AKA Vondran Legal. and we are happy to help you. So I hope this video has been helpful. If you like it, give us a thumbs up. Don't be afraid to subscribe. Keep this good information coming. It's nice to get a fresh look at the law, isn't it? It's something nice aside from politics and screaming all the time. So at any rate, hope you have a great day. We will chat again. We'll see you next week. We got lots of great videos lined up. So make sure you're subscribed and tuned in. Okay, bye now.